Hello everyone, I am Anuj Nakade and welcome to livelaw. This Thursday, a PIL by Dr. Balram Singh on the implementation of the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act of 2013 was listed in the Supreme Court. Manual scavenging is a social evil we are all too familiar with. This is an employment given to a person for manually cleaning, carrying, disposing of, or otherwise handling in any manner human excretion in an insanitary latrine, a drain or a pit, sometimes even a railway station. Usually, the working conditions for the job are horrible, with insufficient or no safety equipment being provided to the workers. Our team had previously released a 40-minute documentary on this issue, trying to platform the experiences of people who have been employed in this profession. If you'd like to know more, please watch that video through the link in our description. There's in fact quite a harrowing representation of the horrible working conditions in a very critically acclaimed movie that you could watch. Chaitanya Tamhane's Court is a legal drama that has a scene where the wife of a deceased manual scavenger testifies in court. She describes in her testimony before the court that her husband would test if it was safe to go in a trench or a sewer by throwing a stone and seeing if a cockroach or insect would fly or crawl out of it. And he would get a holiday if no insect flew out of the sewer. But I'm not a paid film critic, I'm a legal news reporter, so let's get back to the legal issue. The Employment of Manual Scavengers and Construction of Dry Latrines Prohibition Act 1993 and the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act of 2013 has made this practice illegal. It is worth noting that the 2014 judgment of the Supreme Court regarding this issue in a case called Safai Karamchari Andolan and Others vs. Union of India recorded that 95% of the persons engaged in this employment are persons belonging to the scheduled castes and are compelled to undertake this denigrating task under the garb of traditional occupation. In this judgment, the Supreme Court also issued directions to the state and union government to rehabilitate the victims of manual scavenging, along with ensuring that entering sewer lines without safety gears is made to be a crime. Then, in 2020, Dr. Balram Singh filed a petition seeking compliance by the government with the guidelines issued by the Supreme Court in Safai Karamchari Andolan and Others vs. Union of India and the Act of 2013. In February of this year, the court had asked the central government to place on record 1. A status report on the implementation of the 2013 Act, that is, the Prohibition of the Employment as Manual Scavengers and their Rehabilitation Act. Second, steps taken to demolish or abolish dry latrines segregated by state. Third, a status report on prevalence of dry latrines and Safai Karamcharis in cantonment boards and railways. Fourth, a status report on employment of Safai Karamcharis in railways and cantonment boards directly or indirectly, that is, through or without contractors. 5. Details on municipal corporations as well as the description of the technical equipment deployed by such local authorities to mechanize sewage cleaning, also broken state-wise. And 6th, the feasibility of developing internet-based solutions for real-time tracking of sewage deaths and the actions taken by their concerned authorities, including appropriate governments, towards the payment of compensation and rehabilitation of families. The Ministry of Social Justice and Empowerment was directed to file an affidavit setting out these details on behalf of the Union of India within 6 weeks. The court also appointed Advocate on Record K. Parameshwar as amicus curiae on this date. Then, in May of this year, the Supreme Court was told by the central government that All India survey has not been taken yet. One survey apparently was taken in 2018, which covered only 174 districts of the country. On Thursday, a two-judge bench of Justice S. Ravindra Bhatt and Justice Arvind Kumar heard the matter again. During the course of the hearing, Justice S. Ravindra Bhatt asked the Union of India that apart from compensation, if the Union government has taken any other steps for rehabilitation of manual scavengers. He said, and I quote, "Generation after generation, these people are into this. What about rehabilitation? You may pay compensation of 5 to 10 lakhs. Do they get into some other form of employment? Is there some scheme?" The Additional Solicitor General Aishwarya Bhati appeared on behalf of the Union of India and explained to the court that the practical methods and timelines of the survey of identification of manual scavengers. The ASG also informed the court that the Central Monitoring Committee appointed for this issue met on the 5th of July as per the court's directions. The ASG also told the court about a mobile application launched by the central government called Swachhata Abhiyan, where a person can upload data of insanitary latrines and manual scavenging on the app, and the data is then verified by the district administration. However, the court noted that the number of persons reported by the Union of India who are employed as manual scavengers has only increased according to the survey despite the passing of the Act. Justice S. Ravindra Bhatt said, and I quote, "From the previous survey you said only 8,000 were there. In the latest one you say 44,000 are there. If you are right, then after the Act the figures should have reduced. But your own figures are saying that it has increased by not less than 5 times. Advocate K. Parameshwar, who was appointed amicus curiae to the court, also informed the court of the latest statistics regarding the issue and the scheme of the Act. Justice Arvind Kumar asked the amicus curiae how the identification of manual scavenging is proposed to be done. He said, and I quote, "At the taluka level, if you ask them to conduct a survey, the figures may be doubtful. It's a win-win situation for all. The person who does it, he does it for a living, so he doesn't want to report. The beneficiaries will lose their services. They will not report. The others may not know. How do you get over this?" The amicus curiae pointed out that it was important to empower the institutions for implementation of the Act. It needs to be examined how the centre can effectively coordinate between the states and not just monitor and call for data. He said, and I quote, "One of the problems of the Act is that the authorities constituted by the Act in the centre are only monitoring authorities. In an act of this nature, there must be some teeth that the Central Monitoring Committee, the National Commission, must have. If we have to give effect to this Act, some power must be given, not just to monitor and ask for data, but to actually implement the Act." He pointed out that apart from Chhattisgarh and Orissa, none of the states had constituted a state-level survey committee to curb the issue. He pointed out that the National Safai Karamchari Commission is only manned by 2 members when it should be a 7-member commission. The court then decided to treat the matter as part heard and adjourned it for the next hearing. It will be next listed on the 27th of July. We should also mention that last month, the Madhya Pradesh High Court took suo moto cognizance regarding the continuing practice of manual scavenging in the state after it was reported by the Press Trust of India that 2 individuals engaged in cleaning sewage lines died due to not receiving oxygen after entering a manhole in Gwalior. We at LiveLaw intend to provide updates on both the hearings in Madhya Pradesh High Court about the issue and the PIL in the Supreme Court. To get our updates as soon as possible, please subscribe to our channel and hit the bell icon for notifications. If you found the video informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. Thank you.